Hello, I'm Glenn Kirshner, and I'd like to welcome you to an in-depth discussion of one of the most important facets in the practice of law: ethics, civility, and professionalism. Every one of us who has stepped beyond the bar to advocate for a client has done so with the intention of being the best lawyer we can be, to do it right. But along the way, guideposts for professionalism aren't always clear. To examine civility and professionalism in the practice of law, the Senior Lawyers Conference of the Virginia State Bar has joined with the bar's litigation section to gather some highly experienced attorneys and judges to share their insights and help frame some clear markers, some of the do's and some of the don'ts, in the areas of civility, ethics, and professionalism. We've done our best to distill the insights of these experienced judges and attorneys from around the Commonwealth into a comprehensive look at ethics and professionalism, a kind of intensive mentorship session on these topics. Hopefully, you'll find them useful.
Whenever you have people living together and interacting with each other, there's going to be conflict. But for us to live with each other, we have to have a way to resolve our disputes. There's either going to be war, or there's going to be some system that everybody has faith in, that it's going to be fair to each person so that they will buy into this system. And that's what the rule of law is about.
When it's operating at its best, it's always intended to reach justice, to reach a just result. There are many ways to do that, but fundamentally, the best way to do it is make sure that an individual feels heard and that they feel respected and that they feel validated.
I grew up in rural Virginia in the 60s and 70s, and there was a civil rights era. All the rights that we have in the Constitution and the laws, none of them are self-actuating. You can only take advantage of those things if you're allowed to be in court and do so.
As a family law practitioner, which by and large is what I do, I absolutely perceive the rule of law and the judicial system and the court system and the legal process as bringing order to chaos. Because the step one is if the parties can't figure it out for themselves, they usually will then bring in, which is rare, that parties will be able to figure out the dissolution of their marital unit, family unit, on their own. They then bring in an attorney. Then the attorneys, if we can't figure it out with each other, and that's a whole set of issues and sort of respect and cordiality and professionalism in dealing with one another, either with mediators or on our own. If we can't figure it out for whatever reason, then you end up going to a judge.
In many cases, it's the only interaction the average citizen will ever have with the law. You know, they're not going to go to the Supreme Court or Congress, but they might come to court to get a divorce or to get custody of their children or to fight an eviction. I'm just making sure that at the end of the day, justice is delivered.
Litigation is an engine, and our jury system is an engine to get to the truth. We zealously represent our clients and get them to the best spot. And so focusing on getting to the truth and getting, to the right results, I think is best for all the parties involved, and also is kind of the way our judicial system is supposed to work.
The general public wants an institution for which it has a lot of respect, and we owe it to give it to them. It's on every single person that's in that courthouse at any given time, and I mean it when I say it, as does every judge, that when we are in a court, you are an officer of the court, and an officer has duties.
We all know that justice, in all that word connotes, is always the overarching goal. Justice can mean a conviction or an acquittal. It can mean making an injured party whole via a monetary award. It can mean holding a negligent employer liable or vindicating the civil rights of victims. So I think we're all out to seek justice for our client. But when you're in the trenches on each individual case, it's not always easy to focus beyond winning. In recent years, many seasoned attorneys have seen a decline in civility and professionalism, both inside and outside the courtroom. In 2000, the Virginia Supreme Court was so concerned that it added a new phrase to the oath of office. So every attorney now promises that they will faithfully, honestly, professionally, and courteously conduct themselves in the practice of law. So keep in mind, it's not only objectively a good thing, the right thing to do, to practice law with civility and professionalism, it's also your sworn duty as an officer of the court. And unfortunately, it's an oath that some lawyers have trouble living up to.
I have seen in my career, regrettably, somewhat of a regression in civility. I see folks coming into court more frequently. I'm not saying it happens all the time, but greater tendency to want to argue. And when I mean argue, I mean be argumentative, to be short-tempered, ill-mannered. I see it between attorneys at times, with witnesses, and sometimes, regrettably, with the court, with the judge. You can be an advocate and make your point, and when the judge is ready to rule and the judge rules, you say, "Thank you, Your Honor," and if you want to appeal that ruling, go appeal it, but always be respectful. We're not seeing that as much anymore. It's a bit sad, because I think it, primarily, I think it takes away from the effectiveness of counsel's representation.
You can be the strongest, most zealous advocate you can be and be a much more effective attorney by continually showing respect for all aspects of the process.
As lawyers, we all have the responsibility to make sure the system works as well as it's supposed to work. And it's also part of their obligation pursuant to the Virginia Rules of Professional Responsibility. You know, they are advocates for their clients, but they're also officers of the court, and they have to fulfill both of those roles.
I believe there is a growing problem with negative stereotypes. And for people to continue to have respect for the court, they need to come to court and feel that their voice has been heard. If when you go into that procedure, you're getting harangued by your ex-wife's lawyer or whoever's on the other side, and it's a stressful, awful experience for you, and when you get that outcome, you're not maybe going to have respect for the process and for how it worked.
Lawyers need to set the example for the rest of society and how to engage in civil discourse between two opposing parties. You have a dispute, you get it resolved, and I think that with the social media and what people see on television, the image of lawyers projected in the media is being bullies and aggressive and pulling out all the stops and taking the gloves off and that sort of behavior, and that's contrary to the principles of professionalism and civility.
It can be stressful. I want you to think about a very skilled surgeon. And skilled surgeons in the operating room, and they're working on this patient, okay, to save this patient's life. And at the same time, in walks another surgeon, just as skilled. And that surgeon's goal is to kill your patient. Okay? And that's basically what it's like being a lawyer, because you're trying to save somebody. At the same time, there's somebody on the other side of the case, just as skilled, trying to harm your client and harm your case.
It's an adversarial system by its nature. It's designed to be adversarial because the idea is that through people fighting with each other, the truth will ultimately come out. It'll be forced out. It is a brilliant system, and it is a fraught system because it can work, but it doesn't always work. And one of the responsibilities that we as lawyers and officers of the court have is to make that system work.
I haven't been practicing for but 12 years, but I feel like I've definitely seen a drop in not only the civility that attorneys show each other, but probably an increase in their willingness to kind of fudge facts and fudge the law, and that's sad to see.
Some of the worst behavior I've ever seen has been over the last 2 years, and it's hard. It's made our job in particular as litigators incredibly difficult. We are officers of the court, right? We swear an oath when we're sworn in, and the oath is quite clear that our obligation and our duty is not only to our clients, but is to the rule of law. It's to the effective administration of justice. It's to the Constitution of the United States, the Constitution of the Commonwealth. It's a duty of candor to the tribunal and courtesy to one another. That's actually in the oath. It's been a while since I've taken the oath, but I believe it's in the oath that we swear. We swear a duty of courtesy to counsel. And so at some level, if the participants in the system are disrespecting it, how is anyone supposed to have faith in the system? How is anyone supposed to respect it?
I find it highly objectionable that anyone complains about my language.
We've all seen press coverage of bad behavior in courtrooms, usually in states far away. And the more outrageous the behavior, the more coverage it seems to receive. When everyone acts civilly, professionally, and with collegiality in court, it never makes news. But it does make for really good, effective lawyering. As technical advances change the way we communicate and impact legal proceedings, an unfortunate side effect is that unprofessional behavior has been increasing in nearly every aspect of the law, from attorney communications to pretrial discovery and litigation to courtroom behavior.
Stop laughing at my lawyer. Stop laughing at my lawyer.
There has come to develop in the practice of law this, I would call it almost a meme of like the Rambo lawyer. Take no prisoners. You can't push me around. We'll see you in court. And unfortunately, along with being the Rambo lawyer, is utilizing incivility as one of your Rambo tools. And to the Rambo lawyer and to those people who aspire to that, they see the other side of the equation as being a pushover. And I can push this person around, and that is what my client wants. And I think that is the biggest driver.
Excuse me.
I'll see counsel on the sidebar, please.
I've seen it as a lawyer, and I've seen it as a judge. It doesn't help you at all to try to be obstructionist, because we're going to find out what the law says, and we're going to figure out what the answer to the question is. And what you need to do really is to be as persuasive as possible as to why your view of the law should be what we adopt. And it's not, there's no hiding.
All it does is infuriates your adversary and their client. And so it's like throwing kerosene on the fire. The essence of being a good lawyer is that it's to be able to reach some sort of compromise. You can't reach compromise if you're angry or upset or being a bully or belittling your adversary or engaging in personal attacks. Be passionate, but don't go overboard. Lawyers have to learn how to strike that balance.
It's important to maintain the courtesy and civility that you have in interpersonal relationships when you communicate in writing as well. In many instances, I've received briefs from individuals in court where they spend a lot of time really bad-mouthing their opponent or conveying their feeling of indignation because of what someone else has written. And all those things to me just seem like a big distraction. They're kind of like taking away from my ability to focus on the ball, because the ball, right, is the answer to your question.
If you've got an attorney who's just shouting and making the process as miserable as possible for everyone, again, the client may feel like they're really getting their money's worth, but the reality is I I'm not sure that they are, because I think the system is set up in such a way that if somebody's going to misbehave and mistreat the process that much, I'm not sure as much of what you want a judge to hear is going to be perceived and heard through all the smoke and mirrors. It's almost like if there's more smoke and mirrors, your argument must not be as good if you have to make all that noise.
Civility greases the system for everybody. You can get things done. But if you're fighting about everything, you're never going to get anything done. That doesn't serve anyone. Unfortunately, I have seen misguided lawyers, often younger lawyers, take that path and think that that's the way that they're supposed to do it. I think they're just misguided. They haven't gotten good mentoring. It's not that they're bad people. They just mistakenly believe that that's what good advocacy requires. Maybe they got that idea watching bad lawyer shows on television. I don't know. But good lawyers know better.
Lawyers of all people should have the highest bar for having discussions and communications and civil discourse in order to make rational decisions. You may think that you're impressing the client because you're all full of bravado and attacking the other side, but you're not really. You're not producing any work product that's going to be effective in achieving a resolution of the case. You're just wasting time, you're wasting energy, and behaving in a way that is just detrimental to the public's perception of lawyers.
We have to resist the urge to meet nasty missives with another nasty missive. It would be easy to fall into a playground dispute, right, where you're name-calling one another just because you've been working for 18 hours and you got to get this letter out and you can't believe that they sent you another after-hours letter. And those are the kind of communications that ultimately get referred to Bar Council because they will violate ethics obligations. The instantaneous nature of communication that has I think probably impeded our ability to let ourselves calm down before we respond. But I think that means it's incumbent upon us to grow with the technology. And so that means write your email and don't send it. Take a walk around your office, sit back down and reread it before you send it. And we have enough issues that we need to deal with as a whole with the rule of law, and making sure that everyone feels like it is equally and equitably applied to everyone. Without having to add in, attorneys misbehaving, making it even harder.
We want our legal system to work well for us and for our clients, and we want the public to have trust in the system. But what are the individual responsibilities for each attorney? Let's divide the responsibilities into two categories: ethics requirements and professional responsibilities. On the ethics side, there are sworn responsibilities to zealously and competently represent each client. And those responsibilities are paired with the duty to always function as an officer of the court. For the clients, you must competently and diligently represent the client's interest. You must communicate effectively with the client and anyone involved, returning phone calls and emails in a timely fashion, and keeping them informed about the status of the case and any options available. There is a duty to charge reasonable fees, keep your client's information confidential, and disclose and avoid any conflicts of interest.
We have professional rules of ethics that we have to follow. I think those are minimum standards, however. You have to represent your client zealously. At the same time, you can't make misrepresentations to the court or misrepresentations to opposing counsel to get a benefit when you shouldn't. You have to make sure that you're keeping your client informed of everything that's happening and that you're letting your client make the decision and really steer the litigation. You have to make sure that you're forthright with the court, that you don't misrepresent facts or the law to the court.
They are advocates for their clients, but they're also officers of the court, and they have to fulfill both of those roles. And the main thing you need is to make sure that everybody's treated fairly. It's all about making sure the rule of law that they talk about really is the rule of law, and everybody's treated the same, regardless of things that have nothing to do with the merits of their claim.
If you take a silly position in front of the judge, they'll remember that. But when you go in front of a judge and you're constantly giving them the correct law, correct facts, your integrity is not questioned, they give your version of the facts or your explanation of the law more credence, and I think on the long run, that's better for your clients.
As an officer of the court, you're also ethically obligated to maintain candor to the court in all matters. A, this requires truthfulness in all communications, from scheduling issues to pleadings. B, you must always accurately represent the facts of the case. C, you must also accurately represent the controlling legal authority, including informing the court of any adverse authority that opposing counsel fails to mention. D, you must meticulously follow the rules of the court, especially with regards to communications with jurors, opposing counsel, or court staff.
There is a tension between zealous advocacy and your responsibility to the profession, but you can be a zealous advocate without breaching that number one rule, it's integrity. I have seen attorneys who have done things that clearly called their honesty and integrity into question, and people know about that, and the reputation follows them. Judges will go back and they will have their own conversations about that person. Other lawyers, I got so-and-so on the case. They'll say, okay, everything they say, you got to make sure you get it in writing because they'll deny it later on. It's very easy to sort of say, well, so-and-so, my client's making me do it. I'm feeling this pressure to do this or that. If you feel that your duty of the client to be zealous is going to jeopardize your integrity, you got to take a step back.
Attorneys always want to win, but a win at the expense of ethical standards can turn into a costly victory. Time and again, attorneys report that it's their clients who are pushing them into ethical gray areas. And a successful attorney has to know how to control client expectations and demands. And the same holds true, though perhaps somewhat differently, for other participants in the process, witnesses, victims, family members, and the like.
I've said this so many times when we speak to young law clerks. The one thing that you should care most about is your reputation. This client, this case is not worth squandering your reputation over. So you want to win this case, you want to please this client, but you do not want to do anything with this case and this client that's going to adversely affect the next case and the next client. So you need to be extremely attentive to making sure that your reputation is intact. And if that costs me the client, so be it. But at the end of the day, it's a much less costly move than doing something that's going to jeopardize your good name.
You need very quickly, like day one in your legal career, to learn the most important word in the legal profession is your name. That's it. And everything that connotates. What kind of reputation do you have? What kind of preparation do you do? Are you reliable? Are you always combative? And I think if you work very hard and cultivate every day your reputation for hard work, zealous advocacy, and absolute reliability, I think, one, that makes you a better attorney, and I think, two, that makes your job easier. If you slip up, if you cross the line, if you are unreliable, just in this one instance, fill in the blank, if you do that, it will come back to haunt you.
If you have a client who is wanting you to do things that might violate your ethics rules or general professionalism principles, then sometimes you got to have the courage to stand up to them and say, I understand completely how you feel right now, but that's not ethical. I can't do that, and I can't say that. And sometimes you might even have to withdraw from the case if the client really pushes the issue. But that takes some, it takes some courage to do that. But you got to realize that, careers are long. It's not the only client you're ever going to have. And the person on the other side of the case, the lawyer, the judge, you're going to see them again. And when you do, they're going to remember oh, this is the lawyer that did this, this, or that. And people have long memories too. I've heard it said that reputations take a lifetime to build, but an instant to destroy.
Our ethical requirements help foster fairness and equity in all phases of the legal system, and one of the most important and sometimes challenging standards to uphold is candor to the court.
Rule 3.3 under our rules, duty of candor to the court. You're not supposed to misrepresent any facts or introduce any evidence that is false. And if the lawyer comes to learn that the information or evidence is false, the lawyer has the duty to take remedial measures and correct that. They can't just let it slide. They got to fix it. And if you're in court, you have a duty to inform the court of any controlling authority, even though it might be adverse to your client's position. At the same time, lawyers are good at differentiating and distinguishing their clients' situations.
In doing your job, you understand what the law says, and you certainly want to present anything that's helpful to the court in resolving the issue. I think that's a lot more important in a trial court than in an appellate court, because I've got law clerks who are going to research the law for me, but a lot of trial court judges don't, and so they're relying upon the lawyers to provide the research.
The level of trust and dependence from the judiciary on the bar is extraordinary. Scrupulous faithfulness to the law, truth, absolute candor to the court, and honesty to the court. We have to deal with an antitrust case on Monday, an armed robbery on Tuesday, termination of parental rights on Wednesday, and we do our best, but we cannot be up to date with all the law right at our fingertips. We need for our practitioners to advise us on what the law is. And they do that with their pretrial briefs, they do that with their arguments, they cite us to the relevant case law, but we rely on them. And if there's anything that's misleading or missing or withheld, we can't do our jobs, and we might deliver a miscarriage of justice.
The adversarial system only works if you have a neutral decision maker, and that neutral decision maker is given all the facts and the law. And if you have one party that's fudging the law, fudging the facts, then the decision maker can't make the correct decision. They're biased toward these facts that don't exist, or maybe they're wildly exaggerated, and so it does skew the decisions in the wrong direction.
A judge can't resolve a case without understanding the facts and understanding the law. And I was always taught that as a lawyer, you want that judge to believe you to be the truth giver, right? You want the same thing with the justice, with the jury, and in order for you to be able to be honest with the judge about what the law says, you got to know it, right? So you're going to do all your research, and you're going to find out what the law says, and then you're going to tell them a lot of times things are not favorable to you, but even those need to be presented to the judge, and you need to give an explanation as to why. Well, it's just not applicable in this instance, and let me tell you why. Because you don't want to ever be one of those people that a judge feels like is hiding the ball from the judge.
The State Bar's ethics rules are the minimum standard of behavior for attorneys. In addition, attorneys are expected to uphold principles of professionalism that are clearly outlined by the bar, but can be encapsulated in the portion of the oath of office that was added by the Virginia Supreme Court in 2000, requiring every attorney to promise to conduct themselves professionally and courteously.
Courtesy is an obligation of the profession. In 2000, Virginia changed its oath to include the words, "and courteously demean myself." Didn't used to say that. It says that now. Every lawyer that's been practicing, admitted to practice in 22 years, has taken an oath that they will demean themselves courteously. This is not just, yeah, if I feel like it, I will be. No, this is your oath of office, that you will courteously demean yourself in the practice of law, to your client, to your opposing counsel, to your office staff, to the court staff. That is what's required, period.
In addition to changing the oath in 2008, the Virginia Supreme Court endorsed principles of professionalism that had been created by the state bar. These are broken down into responsibilities in 4 key areas: general conduct, conduct toward clients, conduct toward the courts, and conduct toward opposing counsel. All 4 areas require consideration and restraint, and all work to increase individual success while helping our legal system to work better as a whole. In the category of general conduct, attorneys are required to 1. Remember that their demeanor reflects on the profession as a whole. 2. Act at all times with professional integrity so that their word is their bond. 3. Avoid bigotry, discrimination, and prejudice. 4. Treat everyone with respect and courtesy. 5. Act as a mentor for young attorneys, operating as a role model for future generations. 6. Contribute skills, knowledge, and influence in service of their community. And 7. Encourage subordinates to act with professionalism.
Were these magic grits? I mean, did you buy them from the same guy who sold Jack his beanstalk beans?
Objection, Your Honor. Objection sustained.
Are you
Mr.
sure about that
Tipton,
5
you can
minutes?
ignore the question.
Are you sure about that 5 minutes?
I don't know. I think you made your point.
What Hollywood or other depictions of the legal profession depict is exactly that. It's Hollywood. It is not what works in the real world. Being loud, being boisterous, all that stuff. No law school that I'm aware of teaches that. But that is a danger of our current profession, is that the opportunities for young lawyers to step in a courtroom and observe how things are done and observe how things should be done are diminishing. If you see that and see, generally speaking, how ineffectual it is, you're not going to do that.
The quality and the professionalism of the medical malpractice defense bar in Virginia is extremely high, which makes my job easier. We fight about the things that we have to fight about, the things that our clients' interests dictate that we fight about. But there are things we don't have to fight about. And we've all been doing this long enough to know that if we go to court on this issue or that issue, we know how the court is likely to rule. So we work it out among ourselves. And again, if we have to go to court, we will. And there's no quarter asked for nor given. But we're professional. It's not personal. We don't call each other names. We don't impugn each other's integrity or credibility. We stand up, we argue the issues, we argue the law, we sit down, we accept the ruling of the court, and we move on to the next thing.
When I have had some lawyers on the other side of a case, say things that are, rude or mean, I always try my best not to react in a negative way to it. I'll say, okay, well, I understand your position, and leave that be that. When you're in those situations and deciding how you're going to respond to somebody, think about sort of the newspaper rule. If this were printed on the front page of a newspaper that you said X, Y, and Z, are you going to be ashamed of what you said? And if you'd be ashamed of what you said, you probably shouldn't say it.
The attorneys that are most successful are the ones who can zealously advocate for their clients in a courtroom setting while not disrespecting the judicial process along the way and while not disrespecting anyone else. That said, it becomes very complicated when our clients, through watching TV or social media or anything else, want the aggressive attorney, don't feel like they're getting their money's worth if they don't see sort of blood in a courtroom, not literal blood, right? But if they don't see their lawyer jumping up and down and frothing at the mouth, and that's where I have to sit down and explain, and attorneys should be doing this sort of along the way, but I explain from the get-go that while I am absolutely going to represent your interest to the best of my ability in the courtroom, I'm going to bring up every legal argument that I can to make your point. I think attorneys who are able to get their point across without being rude and nasty and offensive in the process are the better orators.
I think the best of the best are the attorneys who can zealously advocate for their clients, and yet when they're dealing with opposing counsel, when they're dealing with issues where a judge isn't there 24/7 to make sure all the attorneys behave, they do behave and they do act honestly. They don't fudge things because they know that's not the best way to represent their clients.
We often define attorney behavior as courtroom behavior, but all attorneys know that the bulk of the work happens outside the view of the judges. As officers of the court, when a judge isn't present, it is each attorney's job to maintain the order of the proceedings, whether it's a deposition, a mediation, or one-to-one attorney communications.
Remember when you were in high school and the teacher left the room, or you had a substitute teacher, which is to say a person without real authority? How did the students behave? Typically, the immature ones behaved very badly. Good lawyers can't afford to be immature and behave like jackasses when the teacher leaves the room. You are not doing yourself as a lawyer any favors. Set aside your client's interest. You're not doing yourself any favors if the judge thinks that you're not capable of behaving properly. Judges need to respect you. No, you cannot be a successful lawyer if you don't have the respect, not just of the bar, but of the bench.
And I wouldn't try that, Ed. Are you threatening to fight? Hold on just a second. No, I want to know whose side you're on. Come over here and try it, you dumb son of a bitch. Wait just a second. Come over here. Hold it. Hey, wait a minute. Hold on.
The depositions are obviously adversarial. You have two attorneys. There's nobody who's managing the deposition, and those can get very heated. And if you have opposing counsel who is not following the rules because they don't have to, because there's not a judge immediately there, those things can devolve pretty quickly. You'll get into motions practice, maybe you'll have to redo the deposition, and really that doesn't have to happen because most of the time, if the attorneys are acting civilly and rationally and following the rules, deposition will happen as it's supposed to happen.
The big thing I would tell young lawyers is know the rules. I mean, understand honestly what the parameters are for what you're doing so that nobody can take advantage of you. In my mind, a lot of things like taking a deposition was no different than when you were a kid and you go to the basketball court. You know, you're calling your own fouls. And that's kind of the way it is in a deposition or something. It's like, there's some people are just being difficult and some people are being outrageous. And you got to no, that's not going to happen. Let's get a judge on the phone right now and bring a halt to this thing because we can't go forward this way.
In professional conduct toward opposing counsel, attorneys are required to treat opposing counsel and their staff with respect, avoid ad hominem attacks. In all situations, you should recognize that opposing counsel is working to serve their clients just as you're working to serve yours. Avoid reciprocating unprofessional behavior. Cooperate as much as possible on procedural and logistical matters. Cooperate in scheduling, accommodating opposing counsel's schedule needs whenever possible, including extensions, keeping them abreast of any schedule changes on your side, and showing up on time for scheduled events. Return phone calls, emails, and other communications promptly, even when disagreements exist. And lastly, avoid being affected by clients' disagreements, remembering that their personal conflict is not a professional conflict between their attorneys.
It's so important that you develop your own kind of North Star, your core values that are consistent with the ethic and civility roles that you're required as an officer of the court, and that you don't allow the situation, you don't have situational ethics where you allow that to change. And so it's just important because for me, I always treat the other opponent as I'd want to be treated. And so even if they're acting ugly, I have found it's an advantage to continue to be kind and forthright, that it's a person who kind of loses their cool, who plays fast and loose with the rules, that more often than not ends up on the short end of the stick.
I think people used to practice, they had respect for their opposing counsel, they had respect for the judge.
We are absolutely bound by our ethical obligations the entirety of the time that we're practicing as attorneys, but I also think it's important to behave that way. And in most jurisdictions, if it gets too out of control, you put the deposition on pause and you call up whoever's chambers judge that day, and you can have them rule.
It's just like you were in court in front of the judge. There should not be any difference. You don't start taking the gloves off just because there isn't a judge sitting on top of you. That doesn't help the client. It doesn't move the ball 1 yard, when you have to do a redo.
Well, then, Mr. Fraser, you would have considered yourself an expert at the time of your employment. Isn't that right, Mr. Fraser?
Objection, leading.
Well, then, let's look at this a different way, Mr. Fraser.
Whatever it is you're doing, if you're doing a deposition, you're doing it for a reason. You're there trying to accomplish something. And if you can't get along, then what you're there to do can't get done. Your client's not served by that. You need to get the job done. And if everybody's running back to the judge, then the job doesn't get done. And the best thing that you can do for your client as well as for your own career is to be a lawyer whom judges respect, whom judges know won't cause trouble, because there are going to be times when you're going to have to appear in front of the judge and argue motions, a continuance or a relief from a deadline, that sort of thing. If the judge has seen you 100 times and 90 of those times it's been frivolous, what kind of reception are you going to get from the judge? But if the judge has only seen you 2 or 3 times and every single time it's been an important issue, a meritorious issue, you're going to have that much more credibility with the judge. What lawyer doesn't want that? Who wants to be the first lawyer? You want to be the second lawyer, the lawyer who has that reputation.
Each time an attorney steps into a courtroom, it's a dramatic moment. The stakes are generally high, the time is always limited. Whether it's a bench trial or a jury trial, attorneys always have a sense of needing to shape their own destiny. But what is the best approach to winning consistently?
We're always trying to figure out as trial attorneys, what are jurors thinking? Why are they making the decisions they're making? So when I became a judge, I wanted to know the answer to that. So I spent a couple of years after jury trials speaking to jurors who had been excused, of course, but speaking with them voluntarily and running through all kinds of questions and inquiries. What permeated every answer that they gave was respect, express or implied.
Jurors do not react well to lawyers that they see as misbehaving. And if you lose the trust of that jury, you're going to lose that case. Jurors pick winners and losers, sort of early on based on personality sometimes and their impression of the person. Are they likable? And that likability factor goes way down when the lawyer's being mean and nasty.
Juries pick up on the fact that an attorney isn't very strong in their position because they see kind of the fear in the attorney's eyes. Juries are very good at that. And so when you start acting nasty in front of a jury, first it turns them off, and second, it questions your position. And just as if you're operating from a place of fear, juries can smell that. If you're operating from a place of confidence in your case, juries are going to pick up on that as well.
Juries don't want to watch people fight. Juries don't want to watch lawyers grandstand and play gotcha. Juries appreciate the solemnity of the work, the importance of it, and they want to see professionals.
It's clarity, it's precision, it's consistency in the presentation. Juries hate if you waste their time. And believe it or not, the lawyers who are playing fast and loose and are jerks, juries a lot of times cannot sort that out. Now, that doesn't mean that your side always wins, right? It's the facts and the law. But they do not appreciate lawyers who are uncivil in front of them or acting the jerk to the witness, get in an argument with the witness, do things that are not necessary in the courtroom. And so when you kind of lose control, which is what happens a lot of times when folks are not civil, you lose perspective. And, you know, I almost like it sometimes, particularly if we're in trial, if someone loses their cool, because that means you're doing something to win, and you know how to kind of push the button to make them look bad, right, in advancing your case. So civility is required as an officer of the court, but also really it's a tactical advantage, I have found.
We analogize it to judo. When they push, we pull. And so when they act aggressively, we try to use that against them. I think at the top tiers, you're looking at attorneys who understand that zealous advocacy does not mean going at loggerheads with the other side. It does not mean fighting everything. And the reason for that is that's not always what's best for your client. Your goal is not necessarily to win every single issue.
He ever tell you that? Yes or no?
Mr. Curry.
Did he tell you that? Yes or no?
Objection.
Did he tell you that?
Objection.
Did he tell you that? Yes or no?
Stop. Objection.
Stop. Your Honor, can I have an answer?
I like an attorney who's objecting at every turn, even though they shouldn't be, who's, you know, being uncivil, because I know that they're not confident in their position, and I know I just have to keep digging, and I'm going to find what scares them.
Jurors said when attorneys objected, they paid attention to the manner in which they objected. And if it was kind of loud and boisterous, the immediate thought to them is, what are they trying to hide? As opposed to calm, cool, and collected. How did they deal with those objections? You know, if a ruling didn't go to their way, were they kind of petulant and sat down? Jurors noticed that.
If the fact finder is looking at two contrasting styles in court, one person who's getting hot under the collar and whose voice is getting louder and louder and who continues to interrupt his counsel, the opposing counsel, interrupt the witness, interrupt the court, who's getting louder and waving arms and pounding on the table, the suspicion that we have, the fact finders of fact, whether that's me as the judge or the jury or all of us, is that something's going wrong with this guy's case. The facts are not coming out the way that he or she thought they would, or he's realizing that the law isn't supporting the position, but there's something is going south here, and that's why he's acting that way. And if you contrast this behavior, this bombastic behavior, with a lawyer who is calm and collected and has the facts right at hand and can respond to the objections clearly and cogently and correctly, and who isn't rattled, who do you think has more confidence in their case?
You might think that your reputation is just interpersonal with the lawyers you deal with. It's not. It's with the courts in general. And we spend a lot of time talking about the attorneys in our court. If you are one who has a reputation for treating everyone you meet with the utmost respect, whether it's the janitor you meet in the lobby right up to the judge or the judge's assistant, that will provide you with benefits in ways you cannot imagine. However, if you are one that turns a light switch and all of a sudden you'll be a nice, well-behaved person only in front of the judge, everybody notices that. Everybody notices that, and that will hurt you. And it'll hurt you in ways, again, that you cannot imagine.
The judges talk. They know the attorneys who appear often. Zealously advocating for your client does not mean fighting every fact, fighting every legal issue, fighting everything that the opposing side is trying to do. And at the end of the day, putting forth law that you don't have a good faith basis to believe exists is going to get back to you, because the judges do their own research and they'll figure it out. They're smart people.
I had a jury trial where one lawyer was doing the Rambo thing, interrupting and shouting. So I took a break and I printed out the principles of professionalism. I took a recess. I said, Mr. So-and-so, we're going to take 10 minutes. I want you to read through these, because it's the court's observation that you are letting your emotions get the better of you, and you are departing from the principles that we expect of all the lawyers who appear in court. So you read through these in, let's take 10 minutes. He was a lot more in control and calm after that.
The two things that, to me, make an excellent attorney: make the complex simple and make the fact finder's job easier. And if, say, you're in a bench trial, who's your fact finder? Your fact finder is your judge. Do you really think that judge is you're making his or her job easier by being loud, boisterous, that even if it's for your client? Or might that judge be thinking, here's a guy that doesn't know enough to know what's going to make my job easier by having a clear, lucid presentation of whatever, as zealous as you want to be, but that doesn't cross any lines? Or by crossing the lines, do you really think you're making that fact finder's job easier? Or are you making that judge fine for you despite your behavior, so you're making his or her job more difficult?
While civility helps maintain order and fairness in the courtroom, it's also essential to helping each attorney make the most efficient use of the limited time available for each case and each client. Professional civility helps make a challenging job more enjoyable, and it helps make good attorneys more successful.
Our brains tend to focus on one thing at a time. So if you're going to be ill-mannered, create side issues, and you have a bench trial before a judge or a jury trial before a jury, it's distracting. And the attorneys that I have seen as a judge, the most effective attorneys, no question, have been the most pleasant attorneys. Polite, well-mannered, respectful to their colleagues, to their fellow attorneys, to witnesses, to the court.
I've been in courts all over the country. A lot of times I'm hired to parachute into a case that's been going on for years and in the end kind of try it. That's been one of my specialties for some time. Good lawyers know how to throw arguments out and to throw things out that, people have fallen in love with and get to the 2 or 3 things that are really going to make the difference in the jury deciding in your favor.
Successful, good lawyers know that you don't get bogged down in minutia, and you're not advancing anyone's best interest by fighting about things that don't need to be fought about. We discard the stuff that we don't need to fight about. We work out what we can work out, and those issues that require litigation are the issues that we litigate. We all have the same goals. Good, successful trial lawyers understand where the issues are, where the issues are not, and focus on those issues and litigate them professionally.
The best thing a good lawyer can do is boil a complicated matter down. That's true. The fun part about judging is when everybody distills for you what you have to decide, and the rest just settles down on its own, right? But when you walk in, they say, Judge, we've resolved all that. We've resolved the pension. We only have these 2 things for you to decide. Then I just think, these people have worked hard. They've got control of their clients. The emotions are not getting in the way, and they have identified the things that really do need a ruling, because things need a ruling.
I think the really good lawyers really understand the issues, and so they can pinpoint them. And I think a lot of lawyers, they mask their failure to truly understand the issues by covering the waterfront. Like, I know it's something here kind of like what you're talking about, so I'm just going to throw all this stuff at you, and you can pick through it and find something to eat. It's almost like, you're the bear, and if you pick through that garbage, I'm sure you'll find something to eat in that trash can, as opposed to somebody being able to say, there's a steak right there, and you probably ought to eat it.
Find a good mentor. Find the lawyers that are doing things the right way, and watch them. Watch their interactions with people. Listen to their conversations when they're talking to opposing counsel.
The best way to win is to recognize that your adversary is not your enemy, to advocate on behalf of your client while at the same time preserving the interests of the system itself. And so you need to behave with integrity. You need to focus on the actual issues and not try to distract the court or your opponent with non-issues. To keep personalities and criticisms out of the picture entirely and stay focused on the issues, the law, and your client's best interests.
We're all in there doing the same thing together for day after day after day, and being able to do it with honor and integrity is important. Certainly important to the longevity, but I think also important to the foundation and the system it's based upon. Civility isn't a pie. There isn't just this much and this piece that's good for all of us. The more civility and professionalism we bring to the practice of law, the more we all benefit.
You can absolutely be a zealous and energetic advocate while still doing all those things. And the point that I would make is that you, one, will be a better attorney if you do that, and two, on balance, you will get better results if you do that.
I will admit that I was one of those attorneys straight out of law school. I thought I had to win every little issue. I had to give pushback on every little thing. And it was exhausting for me. It cost my client money. It didn't bring us to the best outcome. And I've learned at this point that that's not the best way to function. It's much better for our clients if we don't oppose at every turn. And I've learned that through mentors who have taught me.
I think it is most successful when everybody walking out of there feels like whatever they needed that judge to hear got heard and it was appropriately weighed before the decision was made. There is nothing more enjoyable than being able to litigate a really challenging case and walk out of that trial with respect for opposing counsel and for yourself and for how you put on your case and for how the judge ruled and for how the entire thing was handled. There's nothing that feels as good because you've done your job, the system has done it, everything has worked the way it's supposed to.
It's so important for younger attorneys to understand that coming in, that want to make their mark. You don't have to make your mark by being the most aggressive attorney in the building. You don't have to make your mark by yelling and screaming. You don't have to make your mark by never agreeing to anything. The best attorneys stipulate to most of a case. They never argue over things that don't really hurt them because they want to get to the point, because it simplifies and they get it, that they are in the end playing to an audience that's trying to simplify. And if they can help them, they stand best odds at that point of having their argument accepted. The administration of justice is an ideal. We should always strive for that. We may fall short of it. We should always strive for it.
Thank you for joining us today to take a closer look at standards of civility and professionalism in the practice of law. We hope this conversation raises awareness and interest in these issues. We also hope it inspires a career-long commitment to the courteous and civil practice of law. For more information and additional materials, contact the Virginia State Bar. Thank you.